Hello everyone, I am Professor Paul Carrier, and what I'd like to do now is to provide some background material that is relevant to the materials for week 8 of Contracts 1, where we cover in 1 week the concept of breach. Let's remind ourselves where we are. We have just finished with 7 weeks on formation. Formation had 4 primary elements, and within those elements there were sub or components. There were certain tests like an objective test, right, or a current intent, and all of that went into a package to determine whether or not a contract had been formed, because that is one of the things that's necessary to go further. Next week, and for the following 3 thereafter, we will be covering damages, also known as remedies. If something goes wrong with a formed contract, what does a non-breaching party get to compensate for that breach? And in fact, there are some examples where even a breaching party may be entitled to a certain recovery. Interesting, nice multiple choice type question there, and hopefully you'll glean it probably in week 10 when we cover the concept of restitution, which is in fact, well, maybe it's next week, week 9, restitution. Anyway, we finished formation. Next week we're going into damages for contractual breach. The authors of this casebook, including myself, wanted to provide at least 1 week on breach. Many casebooks understand that the concept of breach is kind of a back-ended topic or issue. There are many other things that you need to learn first. And so the concept of breach is not the most poignant, at least not in the early stages of a doctrinal contracts course. We still wanted to put in at least 1 week of it so that mentally, logically, you could make that leap between formation and damages. Hence, week 8 materials on breach. Okay? All right. What we're going to do with regard to breach is cover 3 basic things. First, we're going to ask a question that's less law student and more lawyer-based. It's a kind of a first order, do I have a case or not question. And those are the 3 legal requirements to bring a case before a Florida court. And off the record, if you look in any other jurisdiction in the United States, you will probably find the exact same 3 elements. So now, don't think like a first-year contract student. Think like a third-year associate in a busy legal practice. What are the 3 things necessary to go to court in order for the court to let your case get to the discovery phase and potentially even to the trial phase? There's also motion practice up front, okay? So we'll talk about the 3 major requirements. And by the way, one of those requirements for pursuing a case legally subsumes or presumes that all of the elements of formation have been met, okay? So it's a higher order question with its own requirements that, and one of those 3 elements in fact covers or subsumes the last 7 weeks of formation. I'll explain that in a little bit. What is breached? Well, you could have an express provision in a contract or a very small contract. You paint the garage and you get the money. Garage is not painted, that's possibly a breach. If you promise to paint the garage and you do not, it is definitely a breach of a bilateral contract, okay? And that could be express. There are also implied contracts. There are also implied provisions within contracts, okay? For example, you don't have a specific delivery date in a particular contract. However, for the last 3 years, the idea has always been, the performance has always been delivery by the end of the current month. Then you could imply, in fact, that in this particular contract, breach or controversy notwithstanding, that you imply, based on the facts of activities now and in the past, that there's the term implied that the delivery should be by the end of this month. They're also implied in law conditions, terms, such as a duty to act in good faith, and you may be breaching that. So you may have an express contract and or express provision within it that may be breached. There may also be implied ones. There could be an implied contract, or within an express contract that's not complete, there could be an implied term. And so keep in mind there's the contract part, but there's also specific term parts that also are express or are implied, and they too could be breached. And with a breach, then you go into what we're going to cover in the next 4 weeks after week 8, which is the seeking of a remedy, the attempt to collect damages for that breach. Finally, well, not finally, today we also cover, with regard to breach, another big ticket overall idea, requirement in fact, that even a defendant to a breach action has to think about. And that's the concept of an affirmative defense. If a party claiming breach has to go into court and prove this much to get the proceedings rolling, and later prove out the rest, including factually, there is a first order question that a defendant needs to bring up or lose chance to assert it. And so I'll cut to the chase early. It's basically like an alibi. In a criminal case, if you weren't in the state when the murder occurred, you couldn't have done it. You were supposed to bring that up right away as an alibi. And when you do that, the court can kick the case out against you. The prosecution can dismiss the case because you couldn't have done it. Now, perhaps you hired somebody. That's another question. But you can see that if you weren't unable to do it because you were in another state, then we shouldn't waste court time and court resources. It should take another tack, but it certainly should be dismissed in its current form. Well, there's an idea with a contract as well. If you have an alibi as a defendant, you should bring it up right away, because if that becomes dispositive, the court can get rid of a case early rather than waste time. And we'll explain that in just a little bit. We go over a few examples of breach. And again, breach is something that many case books leave, and it's one of those things where typically you know it when you see it. It's more important to cover the elements. It's more important to cover the damages. At some point, it becomes more important to cover defenses to enforcement, which we will cover in contracts too, than it is to deal with breach. Okay, breach is usually a somewhat final concept, and so we do bring it up a little bit early. And nevertheless, there are certain aspects that make it important, so at least you get a sense that more needs to be gleaned as you go through these cases. One thing, we provide a common law example of breach, and in that particularly, we cover not formation, but we cover whether or not a court should allow a filed breach case to reach the end of legal proceedings, or should the case be kicked out. And you will learn that there are 3 elements. The first one is that there has to be a formed contract. And here's the key. It has already been formed means that it has to have met the 4 elements. Once that's met, we have a contract, maybe with some implied terms. But you have to have that to move to the next question. The second question is there has to be a breach. Now, did the person fail to paint as promised? Did the person deliver goods that are substandard based on what you ordered? That is also a breach. And so if a breach has occurred of a formed contract or terms within a formed contract, then you get to the final phase. There has to be actual damage. If there is a breach but no damage, no harm, no foul. What if a contractor breaches the deal for making a house and you're not quite happy with it, but it doubles the price of the house? I'm sorry to say, unless you have a really strong claim on aesthetics, having a double value house for breach probably means you have no real damages, and you should get out of that court and walk away and sell the house and get the cash rather than waste a court's time. No harm, no foul. So the 3 elements to get a case to the full level of proceedings: there has to be a formed contract. You have to have satisfied week 7 or 1 through 7 materials. You have that, then you look at the term or terms, express or implied, that have to be breached. And if they have been, then you have to show damages. And when someone claims breach, the other side can bring up the concept of an affirmative defense. That's like with criminal law, I mentioned alibi. In contract law, often it's, for example, failure of a precondition. Quick example. let's say that I agree to buy your car if I get a new job by the end of the month. I can't afford it without the new job. The contract doesn't include the statement about getting a new job, but as I talked to you and shook hands and wrote, I'll buy your car, that was in our minds. Okay, so we can imply it in fact. That is a precondition. If I don't get a new job, the contract is not actionable. And so, if I have the defense of there was a condition before the contract truly formed, integrated, was empowered, arose, otherwise began its machinations, I am supposed to bring it up right away. Because if I'm right, the court can use that to dismiss the case, to get rid of the case earlier rather than waste the court's time. And if you fail to bring up one of these affirmative defenses and you risk wasting a court's time, you can actually lose the ability to make that claim later. So there's a penalty procedurally if you fail to bring it up quickly to help the courts get rid of a case that shouldn't be there. Okay? We cover one sale of goods case and breach, and we begin to alert your attention to something very specific with sale of goods, and that is the perfect tender rule. And that is something over the course of contracts law and possibly even a commercial paper, a commercial transactions course, you will learn more about it. But you need to keep in mind what the standard is for claiming breach of a sale of goods contract. And it's simply nonconformity with the terms of the agreement. And if there's a nonconformity, that allows rejection. You could simply say, take it back, or I'm not accepting it. Okay, so there's some special rules, and you should become familiar over time with the perfect tender rule. So begin to familiarize yourself with the concept now in the case that we provide in week 8. But you will see it again. Okay, finally, and this is critical, there is one particular category of breach that is highly testable, very, very interesting, very, very specific. And so this is something that should be taken to heart. It's called anticipatory repudiation. And the idea is, if somebody who has a contractual duty knows that he or she or it cannot perform, it may inform the other side. We cannot perform. The widgets are at the bottom of the ocean. We don't have another supply. They'll never get there in time. There's nothing we can do. So you can wait until the end of the month and we breach, or you can treat it like breach now and you can move forward now with breach and maybe help save the problem by acting quickly rather than later. The key there is that the indication of breach has to be unequivocal. Okay? And here's the real kicker. What if someone says that they're worried if they can perform? They're not sure. That is not unequivocal. That is equivocal. And so, what if they think there might be a problem but they're not sure? And you treat it as breach right away. You may have acted too soon. And if you have acted too soon without an unequivocal indication of breach, without this proper anticipatory repudiation, you who act too quickly become the breacher. Okay? And another thing to do, if you don't want to be the breacher and you have an equivocation on whether or not the other side will perform, you have the right to demand adequate assurance. You can send an email, you can call, you can send a fax. I'm worried, I got some information, you may not perform. Please assure me that you can perform. And if the other party fails to answer, then you have the right to treat it like breach. It becomes, at that point, unequivocal. Or you might get your answer that everything's fine, whatever. So one of the keys there is you think there's a breach, and if you're pretty sure, you can treat it as breach right away and move forward at your option as a non-breaching party. If it's a close call, you might be the breacher for precipitating the termination of the contract, and you'd better wait. And in the period of waiting, you can demand adequate assurance, right? And so, by the way, the common law test for anticipatory repudiation and the right to demand adequate assurances is very, very similar to the sale of goods Article 2 version. There are two specific differences that hopefully will become clear during class, and we'll cover it later. Okay?